Welcome to this meeting of the House Judiciary Committee. I apologize, we're a few minutes late. Everybody's struggling with quorums based on the meetings, the way they got scheduled, with this being a non-legislative day. But we're going to make it happen. So with that, Madam Secretary, please call the roll.
Representative Banta.
Here in person.
Representative Blanton. Representative Bratcher. Representative Cantrell. Here. Representative Decker. Here. Representative Elliott.
I'm here in my office.
Thank you. Representative Fisher. Representative Heverin. Representative Kulkarni.
Here in person.
Representative Lewis.
Here.
Representative Maddox.
Here.
Representative McCoy. Representative Minter.
Here.
Representative Mosier.
Here.
Representative Nemus.
Here.
Representative Petrie.
Present from my annex office.
Thank you. Representative Scott.
Present.
Representative Stevenson. Chairman Massey.
Here.
Quorum.
And we do have a quorum and we're ready to do business. As I've said in every meeting this year, please be mindful that the recording equipment is very sensitive. So if you have a phone, please put it on silent or do not disturb. Also, when you speak for the meeting today, you need to make sure your mic is on because KET does not pick it up if it's not on. So please be mindful of that. We have 3 matters today, but we have a very heavy agenda. I expect the meeting will go probably 2 hours, and here's why. The first bill we're going to consider today is House Bill 551, and as those persons make their way to the table, I'll explain the rest of the agenda. Today we're going to hear 551, and we're going to try to keep that to 30 minutes. We're going to give those speaking for and against each 15 minutes, and then we'll have to move on because the second part of our agenda will be for discussion only, but it's on House Bill 21. Representative Scott will be presenting that along with her witness. This will be here today. And then following that, and we've allowed them 45 minutes, and then following that, we will have President Stivers with Senate Bill 4. Both of those deal with the no-knock warrant situation, and so there's some overlap there, if you will. I've explained to people that have asked, they ask, why are you calling one for discussion only and one for action? Realistically, in the limited time that we have left, the realism of it is House Bill 21 is not out of committee yet and would have to go through the whole process. Senate Bill 4 has cleared the Senate, but I'm sure that there's going to be some questions and likely some floor amendments that will have to be dealt with. So that is going to be the process. I've explained that to the presenters, including Representative Scott and President Stivers. So with that, we're going to take up House Bill 551, and I do want to say a couple of things very early on with this. This bill was heard for information only last week, and you might ask, why is it back here so quickly? And the reason it's back here so quickly is upon the conclusion of the meeting, I was contacted by the sheriffs and by some other folks that really have an interest in this bill. Unfortunately, one of the complaints I've heard is that we should not be dealing with things that deal with courtroom procedures, but I will say candidly, those procedures often affect other parties that don't necessarily have a voice through the court system. And so we agreed to have this bill heard. There is a committee sub, and I'll ask for approval on that in just a moment, but it changes the shall to may, which means this is permissive and not mandatory. So we do have a committee sub. Is there a motion on the sub?
Motion on committee sub.
Is there a second?
Second.
Okay. All in favor signify by saying aye. Aye. Opposed? Okay. So this is permissive. We do have people lined up to speak, and some of them are in person and some of them are by Zoom. But with that, I'm going to turn it over to Representative Freeland. You may proceed.
Thank you, Mr. Chairman. Thank you, ladies and gentlemen. House Bill 551 is an idea that was given to me, and actually all of the work that has been done has been done by a circuit judge in my district, Judge Jamie Jamison, and he is with us virtually, Mr. Speaker. And also I want to thank Ms. Shelley Hampton with CAECO for being here, and this is an important issue for our county associations as well. And I have a letter I'll read if time permits from the Jerry Wagner, the executive director of the Kentucky Sheriff's Association, who is also for this measure. And with that, Mr. Chairman, I would like to allow Judge Jamie Jamison to explain this bill and what we're asking for.
Thank you. And Judge Jamison, I will qualify this. I want people to know when it was for information only last week, there was a committee sub, but because we didn't call it for action, the committee sub there was never adopted. The committee sub that would have been presented is in conflict with the committee sub that's been presented, changing the shall to may, which is why that committee sub is not being called today. But Judge Jamison may refer to that in his comments, and I just wanted to make sure everyone was clear. With that, Judge Jamison, you may proceed.
Thank you very much, Mr. Chairman, and also Representative Freeland. I appreciate this body giving this the time that it's been given. I want to say up front, as I did last week, I do not represent any group of judges or the Circuit Judges Association or District Judges Association. I believe you are going to hear from some of our leadership on this with legitimate concerns. And I also want to say that the original bill came out with the intention of, through the process, as most bills do, being modified to accommodate concerns, needed changes. And those conversations were had with the Commonwealth Attorneys Association, County Attorneys Association, Sheriff's Association, Jailers Association, and CACO. I have since received communication from the Jailers Association that I don't know if they're in the same position that they were before, but I want to make it clear that they were in support of the committee sub that was intended for last week. How those are different is the original bill makes it all mandatory. The proposed sub for today would not make it all permissive. That was discussed with all of those organizations that I just named, and that was not their chosen option. The language that reflects what they all endorsed and approved of is in that committee sub that was intended to be discussed last week. I hope the committee members have seen that. So I'm going to talk about the different ones. The sub today would just do exactly what the chairman said. It'll make it permissive where courts can choose to participate in this, but they don't have to in any circumstance. The committee sub that was gathered as a result of the conversations with those organizations I named would make one situation mandatory. It clears up some things, takes away some of the language that could cause separation of powers issues, in my opinion. Although I'm not saying it necessarily cures that. That's a decision that'll have to be made by the Supreme Court if it's ever challenged. But the important change in the bill is it does make it mandatory for courts to require a defendant to appear virtually, but only when that defendant is held in a detention facility outside of the circuit where the defendant is being prosecuted. Talking with sheriffs, talking with jailers, getting on the ground, my 10 years or so as a public defender, you see these guys having to get up at 1 a.m. And drive halfway across the state, pick up an inmate at a, say Eastern Kentucky prison, et cetera, drive all the way back to Marshall or Callaway counties for an arraignment that takes less than a minute, literally. And then they have to drive them all the way back. And I can sit here for an hour and name all kinds of scenarios that I've witnessed. That is something that occurs regularly in our courts, unfortunately. I think to some extent out of tradition, but also out of legitimate concerns for confrontation, et cetera. What I wanted to point to is the version of the bill that gets finalized. Devil's always in the details. What I support is the idea of eliminating those long distance trips that don't result in anything other than a continuance or an arraignment or something that is going to last more than just a couple of minutes. And Kentucky case law, in my opinion, is clear that confrontation is only an issue if there's some sort of evidentiary hearing occurring or a trial. So anything other than that, there are examples of case law where arraignments were held virtually or at a distance, and that was held to be absolutely constitutional. Now, those things may change. Obviously, all that's in the hands of the Supreme Court as they desire to modify those things. But that's where this is coming from. Is there is a circumstance, a situation here that needs addressing, in my opinion, and I think there's a lot of individuals that share that, including some judges. And it's more of an issue of devils in the details. How do we get there? Perhaps, in my opinion. So I just wanted to make clear that the language that all of the groups I named had input in and said that they supported is the committee sub that was to be discussed last week. And that has the teeth of making it mandatory for these virtual appearances, but again, only where the defendant is held out of the circuit where they're being prosecuted. So judges, absolutely. And it also takes away application to district courts. So it only applies to circuit court. So district court under that version would be all permissive. And it has some lines in there that ensures protections of defendants' rights. A lot of work was put into that version to try and reflect everybody's concerns to the extent possible. Again, it's folks disagree on things, but the concept of saving the money that we're talking about. I don't know if the committee members got to see the corrections impact statement, but I thought this really told the story, if I may, Mr. Chairman. I'm going to read just a little bit of that. It says, availability of video court hearings would be very beneficial for revocation hearings, providing probation and parole officers for other areas of supervision. So what you have often is a probation officer that may have to travel several counties for a hearing that oftentimes isn't even held, or if it is, doesn't last more than a minute or two. Reduction in prisoner transports would be very beneficial for the department in terms of individuals serving a sentence who had pending court cases. The reduction of transporting prisoners to court would increase officer safety, reduce overtime cost, and allow for reallocation of staffing resources. And here's some good numbers that I think kind of drive this home. Over 3,000 state inmates have detainers for pending charges. This is in state custody, with 43% located in prisons and 57% located in jails. In 2019, the department averaged 325 court trips per month. That's just for inmates serving state time. So that's not where the majority of your movement comes. The majority of your movement comes from individuals that are in a county elsewhere that have new pending charges in your jurisdiction. This is a cost of approximately $75,000 in staffing each month, not including other transportation-related costs such as mileage, gas, etc. Any transport outside of the correctional facility poses higher risk for staff safety. Most importantly, the reduction of inmate transports increases public safety. So that again is from the corrections impact statement that was produced as a result of this bill. So with that, I'll be happy to answer any questions. I'm not necessarily here to advocate for the bill. I'm here to advocate for reducing these unnecessary costs, regardless of how that's done.
Thank you, Judge Jameson. With that, Representative Freeland, I know you have another guest that's prepared to speak here today.
Yes, if it's okay, I'd let Ms. Hampton speak with CAECO.
Thank you. Thank you, Chairman Massey, members of the committee. My name is Shelley Hampton. I'm the Legislative Director for the Kentucky Association of Counties. Thank you to Representative Freeland for serving as the primary sponsor of this proposal. Also want to thank Chairman Massey and Representative Westrom for co-sponsoring this very important issue. Of course, we want to thank Judge Jamison for his heft and his lift for this as well, and his interest in continuing this option of reducing unnecessary trips outside of that judicial circuit where defendants are held whenever that's possible. It's an important piece, this bill is, an effort on the part of county officials to not only be good stewards of the tax dollars they are entrusted with, but also to stop the shifting of costs from the state down to its partners at the county who provide mandated state services statewide, but often with no accompanying state funds to cover those costs. In the interest of time, I'm not going to repeat what's already been said. I will tell you that the time that this takes a deputy off the road in their respective county when they could be responding to a 911 call or serving a warrant, and the costs that are associated, as you heard from the corrections impact statement from Judge Jamison, can reach into the hundreds of thousands a year. While the world begins to see a light at the end of the tunnel through COVID, there have been some valuable lessons and some positive outcomes as a result of adjusting to the limitations that the pandemic has set upon all of us. Utilizing technology in this instance to save time, taxpayer dollars, and maintain public safety is one of the silver linings on an otherwise terrible pandemic, as virtual court appearances became more and more of a necessity. It has reduced time away from performing duties in the sheriff's office. It has saved time for deputy jailers who are able to keep defendants in the facility instead of going through all of the precautions of preparing them for transport out and then back again, while assisting them in appearing virtually in a courtroom that could be hundreds of miles away. Public safety and costs have been saved in sheriff's offices around the state during this pandemic with this order, and it has saved fiscal court's money by eliminating these trips back and forth. Again, we support the option of extending this practice permanently wherever possible, and we would ask for your support. And lastly, I will reiterate that the following groups continue to support this effort: the Kentucky Sheriff's Association, the Commonwealth's Attorneys, the County Attorneys, Kentucky Jailers Association, and the Magistrates Commissioners Association. Thank you, Mr. Chairman.
Thank you very much. And I think the last piece of your testimony, Representative Freeland, was the letter from Mr. Wagner. I believe he's in Florida, and he wanted to see if he could be. It's a short letter. If it could be read, correct?
Yes.
Okay, you may proceed.
Thank you, Mr. Chairman. Jerry Wagner is the executive director of the Kentucky Sheriff's Association. He is at the National Sheriff's Association, so could not be here in person or virtually with us. But he did ask this to be read. He said the Kentucky Sheriff's Association Board voted to support House Bill 551 in a meeting held on March 2nd. Recently, there's been discussions with the change in wording, changing the shall to may, and may appear remotely with a committee substitute. The KSA still supports HB 551 with language changes, as the KSA believes this will save the Commonwealth and the counties a significant amount of money. Thank you, Jerry Wagner, Executive Director, Kentucky Sheriff's Association.
Thank you, Representative Freeland. I know that we have some people that have signed up to speak in opposition, so if you could vacate for the moment and we'll call them up. We have Damon Preston from the DPA office. We have Judge Foster Cutoff and Judge Cunningham. And I believe that I was going to call Mr. Preston first if he's available. Is he in person or Zoom? Okay.
On Zoom, Mr. Chair.
Very good. You may proceed.
Thank you. I'm going to be quick because I know others want to speak. Here, I would sum up DPA's position on this bill in one sentence. For those of you that have children or are aware of what's gone on in schools this year, if you believe that the kids of Kentucky have received a quality, comprehensive, and equivalent education over the camera over the last 6 months, then you should be for this bill. Camera court is quite simply not regular court. The experience of a criminal defendant whose ability to understand the proceedings should be the paramount, should be a paramount concern of the court system, is simply not present over the camera. DPA appreciates the language that's in the committee substitute, allowing a secure audio connection between the attorney and the client. That has not been present for much of this time when we're trying to kind of making up the rules as we go. But I appreciate that. But I want everyone to understand the limitations of even that. While I may be on a direct connection. If I call Chairman Massey right now while he's sitting in a crowded room and he answers the phone on the microphone, he's not likely to say that that's a private communication. And yet that's what this would set up. The client is sitting or standing in the jail in a room with 10 to 15 other individuals who may have an interest in hearing parts of that conversation that they could use to their advantage, as well as jail security officials. In addition to that, when the client is watching the camera, they are seeing just what's on the camera, obviously. They're not seeing the prosecutor. They're not having conversations with other people within the court system. They're not getting the full feel, just like our children in schools are experiencing less than the full experience of school. So I don't believe this should be seen as a full-time, a permanent solution. To Judge Jameson's point about very short court appearances, first of all, I would say DPA is not categorically against ever appearing on camera, but I believe that should be individualized, decided in specific cases with specific clients. Sometimes our clients are going to want to appear remotely because they don't want to go through the trouble of this transport. But that should be decided locally, not on a statewide basis. The second point I want to make real quickly is that this is being framed as a cost savings bill, but it's really a cost shifting bill. DPA will be required to employ additional attorneys because in a lot of these hearings, we will need to have an attorney both at the jail to have a truly private conversation with the client and in the courtroom to negotiate a case or to appear in person. This is going to require additional resources for DPA. It's going to require additional travel because while there may only be 1 minute at the podium in the courtroom, when a client is transported over a distance to the courtroom, we maximize that time. We may be sharing discovery with the client. We may be having a conversation about the evidence against them. We may be talking about a deal that's on the table. Those things will not be able to occur from a distance, and as a result, we will be traveling that distance. And so it's just shifting state costs. It's not really reducing it. This bill is all about viewing the court system as a purely transactional experience, that essentially we're selling a car and we're just trying to work out a deal. But there's so much more that goes into an in-person court appearance. We've been willing to go along during COVID because it's better than no court at all. But this bill would put into the law an ongoing process for camera court that really should be thought out with more deliberation than is possible here in the last couple of weeks of the session. This should be decided by the Court of Justice through a conversation with all the stakeholders, including the sheriffs, including the jailers, and other groups that have come out in support of this bill. The last thing I would say, and others may comment on this as well, is there is specific language. I'm not going to break it down here, but there's specific language in this committee sub that really doesn't work. Changing shall to may seems like a simple change, but it's unclear what may even means. Who has the right? Does this mean a judge can't order an in-person court because there's a right that the jail could assert that it may occur virtually? May is not as clean a language as you would think because there's multiple players here, and who gets to enforce the may is a question. There's some other issues like that really should be discussed more. So for these reasons, DPA is deeply concerned about this bill. We would ask that it be held for discussions in the interim in the legislature if desired, but I think more appropriately within the Court of Justice. Thank you for your time, and I'll answer any questions.
Thank you. We will now have we have Judge Cutoff and Judge Cunningham, and I believe Lori Dudgeon from AOC. I don't know if she's still going to speak or not, but we're going to try to be brief. We've got about 7 or 8 more minutes, and then we have to move on. But I know we're going to lose a couple of members, too, that have to go present other bills. And I believe we also have Representative Petrie that is in another committee meeting. So we're going to be as mindful of those votes as we can, but please proceed as quickly as you can.
Go ahead, Judge Cutoff.
Good afternoon, Chairman Massey and members of the committee. Thank you for having us here. I'm Foster Cutoff. I'm a district judge in Christian County, and I happen to be the president of the Kentucky District Judges Association. So I'm here speaking on behalf of my compatriots in district court. I want you all to know that speaking technically against this bill does not make us against saving money, and it does not make us against deputy or officer safety or health. It makes us, in my association, pro-court is the way I look at it. The permissive language is great, I guess, in the sense, and that tells me I don't have to do it if I don't want to do it. It also tells me I don't know why we're doing this if it's completely permissive. I do feel, and our association feels, that this is best to come from the Supreme Court via a court rule. Judge Jameson noted all of the associations that spoke in favor. There were no judicial associations with the Supreme Court listed because they haven't been reached out to talk about this. Justice Michelle Keller heads the Criminal Rules Committee for the Supreme Court. It's green.
Okay. I know some people that are remote have indicated they're having a hard time hearing, so maybe speak closer.
I'll speak a little closer. Justice Michelle Keller is in charge of the Criminal Rules Committee, and she has indicated and said she will talk about this in the interim, get her committee together to discuss a court rule. And I'll tell you, I mean, virtual court, it works for some things. We do it all the time, but Mr. Preston's correct. It's not always the same as real court. I'm not going to tell you all the stuff I see on a daily basis in district court. I'm dealing with 60, 70, 80 people on Zoom. It's one of my judges emailed me and said we've kind of lost the gravitas of court from being online. And that's true to an extent, but we get a lot of things done, and the Supreme Court has given us orders and given us direction to do this, and we have. And as a court of justice, we've persevered, and we've taken care of our caseloads to the best we can. But we need the capability, and we need the possibility of having an inmate brought to us if we, as a judge, determine that needs to be done. And the legislature has already taken up the issue of transport and directed that that's a sheriff responsibility. So if a judge signs a transport order, the sheriff's to transport. Never had a problem with that in Christian County. My sheriffs or my jail people, they've never had a problem bringing inmates to court. And I know that's a burden on them sometimes, but again, no problems. So we think, as the District Judges Association, and I think AOC in general, the Court of Justice, that speaking about this in the interim would be best. There are lots of things to discuss. There are things that can be built on and continued, but there are many things that need to go a different way. So I will pass the mic.
Mr. Chairman, hopefully I can do this in a minute, 2 minutes or less. I'd like to thank the members of the committee for letting us be here today and speak. And Chairman, I particularly want to thank you for reaching out and communicating with us about this measure. Also want to thank all of our partners who are sitting behind us, who are also our friends in the Jailers Association and CAICO and the Sheriff's Association. Without our working relationship the last few months, we would not have gotten through this pandemic as well, frankly, as we have. The Jailers Association Executive Director and I are on the phone almost daily during the worst few months of this, trying to work out issues in different counties. One of, I think, our primary concerns, as I've mentioned to the chairman, is we feel like this is premature. As Judge Cutoff mentioned, the Supreme Court wanted to make sure that this committee was aware that the Criminal Rules Committee is planning to take this up as soon as possible, which will be soon. I think a lot of folks know, the lawyers in the room know, that any proposed criminal rule change has to go through notice and comment in front of the Kentucky Bar Association. So it's a pretty vetted, suggested rule change, which I think is important. Justice Keller mentioned yesterday that certainly that the sheriffs and the jailers and CAICO will be engaged to weigh in on this in the future. And lastly, really the only thing I wanted to speak to, I appreciate the transport costs that would be saved, potentially estimated at $75,000 a month. We have not been asked to provide a fiscal note on this bill. We have incurred some pretty significant costs through the pandemic to try to make this change as quickly as we have. But we do have future annual anticipated cost ongoing of about $1.7 million. So I just want to make sure, as Damon Preston said, sometimes it's cost shifting, and it is all of our taxpayer dollars that we're trying to save. As Judge Cutoff said, I personally am, frankly, a large fan of remote proceedings and doing as much as we can remotely. I think we're seeing cost savings in our statewide programs as well in terms of travel. But I think with respect to the developing case law across the country right now on whether sentencing can be done remotely, whether revocation hearings can be done remotely, this is all still very fluid. We're expecting the federal courts to weigh in on what's constitutional. And for those reasons, I feel like, Mr. Chairman, respectfully, that this legislation is premature at this time.
Good afternoon. I'm Charlie Cunningham. I'm a circuit judge in Jefferson County. I am the president currently of the Kentucky Circuit Judges Association, which has all of our circuit and family court judges essentially as its membership. I'm not going to, I put my thoughts in writing, so if anybody wants to read them, they're there, because I know you're short on time. I did not, however, want to have a situation where a circuit judge spoke in favor of the bill and you didn't hear someone speak in opposition. I brought a colleague, Angela Bissick, one of my other circuit judges, just to manifest that we don't think this is the right process. We understand the motivation. We are anxious to participate in discussions to balance everybody's responsibilities, to fix things and make it better. But with all due respect, this is too rushed and too blunt an effort. And we would respectfully suggest that you should not vote for it. Next session, there'll probably be some legislation that would be appropriate that would tell everybody what their job is. But candidly, if y'all tell me how to run my court and the Supreme Court tells me how to run my court, I'm going to do what the Supreme Court tells me, because I got to. Thank you.
Thank you very much. I know we have one other person that was on Zoom, I think Attorney Philip Lawson. Unless, Mr. Lawson, it can be ultra brief because we have got to move on. If it's anything that's already been said, you can indicate that, but if you have anything to add in a minute or less, please feel free.
Thank you, Chairman. Thank you, members of the committee. I echo a lot of what's been said. I just want to make sure that the committee and the chairman know that, from KACDL's perspective, we think Zoom court has a place, but going about defining that place is a very fragile, process and a very fragile way of defining it. So we echo what Mr. Preston has said, what the judges have said, and we think the best process would be, let's get in the interim, let's get all the stakeholders together, and let's flush this out in the interim.
Thank you very much. At this point, we'll take some questions before moving on. We have Representative Banta.
Thank you, Chairman. I'm a little bit confused, and I need you to help me. Since it makes it totally up to you, you can decide whether you want to do a Zoom or not do a Zoom. What's the issue? Because it's still your court. You can do it or not.
Part of the issue is the process, ma'am. The Supreme Court constitutionally is tasked with creating administrative court rules, and personally, I think it's a slippery slope when you say, okay, you may do this. And I don't think this would happen, but I could see a situation where the jailer or the sheriff in that particular county comes back to you guys and says, hey, that judge is choosing to not do it over and over again, and we really want them to. And it just, if it says may, you're saying there's no reason not to do it. I don't see there's any reason to do it. We're doing it now, and I will tell you, most of my judges want to keep doing this to an extent. It benefits attorneys, it benefits some defendants, depending on the situation, but there are lots of different court appearances that would go much better, really would take care of the defendant's rights better if they were in person.